calls, because then when they speak, it places...
Have you provided to the defense all recordings by Mr. Hernandez, so that they could go through and look at them and see whether he says that to everyone, not just to people like Ms. Singleton, who the Commonwealth is alleging is doing things he's trying to encourage not to talk.
They have all the recordings.
Thank you. Second recording.
And so this is just now further into the conversation. There's further discussion about...
So this is the same conversation?
It is, Your Honor. And those three transcripts, those are... And I just would maybe reference sort of the way...
I don't have the date.
If I could just add at this point, Your Honor, that's the first time we've ever heard that those are the same conversation.
Okay, I don't have the dates on them.
I apologize, Your Honor,
so
but...
do you know the date of the first one?
I do, Your Honor, because you'll see there, and that's the way I've laid them out in my memo as well. They describe July 12, 13 on the front page.
Okay, so this is July 12th. And then the next one on the letter is similarly July 12th, right?
Correct, Your Honor. And the call is at 13:03, and then we've just serialized the...
So I hear your argument on that one.
And so this is just further into that call, Your Honor, where they're further discussing being careful about now specifically watching what you write, because people are reading what is being written. And again, it goes to this concept of their states of mind when they then speak about certain things.
Your Honor, I would make a similar argument which we've stated in our memo. This is nothing more than a statement of an obvious fact. I guess I don't have the ability to stare at this like it's a Rorschach ink blot like the prosecution and read nefarious motive into it. It is just two relatives talking about the reality of prison or jail communication. And for that reason, I think under the 403 balancing that was endorsed by Spencer, I think it has the capability, especially now that we know that these are chunks or blocks of conversations taken out of context, set out in stark relief. It has the likelihood to confuse and mislead the jury, and we would ask that it be excluded.
Thank you. The third one.
And so then, Your Honor, this...
is also 7/12.
7/12, yes. And I know you've asked me to address these first, but put it into context, Your Honor, is this call comes after Ms. Singleton has already spoken to Mr. Wallace earlier in the day. So I just offer that as well. And here, Your Honor, the defendant, in the course of his back and forth, indicates to Ms. Singleton, don't say nothing. And she says, I'm not saying nothing. And it's the Commonwealth's contention, Your Honor, that this call occurring on July 12th, and when you now ultimately, as we head forward, when Ms. Singleton comes to the grand jury on two separate occasions, after being given ample time by a Superior Court judge to consider her grant of immunity and her obligation to testify, in fact, says nothing. And so that's the purpose of the Commonwealth's, including...
Is there anything in the recording that reflects what that is?
There was a number of conversations between them, and I've listened to it, Your Honor, and I just don't have the exact memory, but they're clearly talking about something else first.
Well, Your Honor, this is precisely the reason why we've objected to this conversation, because, again, cut out in isolation and put here out of context. As the court heard evidence yesterday, there was a previous relationship between the defendant and his cousin. There was a support relationship. There was both for her children and for her. And we believe that is what that refers to here, and that is a private matter that Mr. Hernandez is asking Ms. Singleton to keep private. There is this extraneous evidence about timing and context regarding a call with Mr. Wallace has nothing to do with this transcript, which is before the court. And I would submit, Your Honor, that this is an excellent example of the danger of confusion, misleading, and speculation that will occur if a conversation like this is placed before the jury, and we would move that it be excluded.
The thing about this idea of, well, the Commonwealth's aid contextualizing, the defendant has had these calls. The defendant then was provided these particular transcripts.
When, on what date did the defendant get the transcript?
I believe in December, Your Honor.
The transcripts?
Yes.
Yes, Your Honor. In discovery, Your Honor, let me just maybe expand on this. In discovery, we received what appears to be a complete download of months and months of conversations that the Commonwealth obtained from the contractor, I think it's called Securus, that runs the telephone system for the jails. Months and months and hours of conversations. Impossible to listen to in any meaningful way. For that reason, if the court recalls, we had a motion hearing and we talked about these jail calls, and the court requested that transcripts be provided to the defense of the conversations that were intended to be introduced by the Commonwealth.
But you had the transcripts.
December 31st, Your Honor, we received 6 emails with the transcripts. Every one of those transcripts regarding Mr. Hernandez is in this submission.
Thank you.
And Your Honor, we've had an assistant district attorney listening to these calls, and we've listened to them. We've presumed defendant's counsel has listened to them. We then focus them in on the particularized calls to the extent that it is very easy to find them. They have the dates of the call on them. They've had them for the calls themselves for an extraordinary length of time.
But they've had the transcripts, you say, since December 31.
So to boil it all down, as you recall, Your Honor, because the court asked us to boil it all down, we boiled it all down, and when we boiled it down, we provided them the transcript.
But I guess what I'm trying to find out is, while you've now excerpted the portions of the transcripts that you want the jury to hear, were physical transcripts as opposed to the recordings provided in December?
Yes, so they had the recordings far before, and then we followed up with the transcripts just as the court asked us. And it's really no different, Your Honor, than if you take a defendant's interview, which we do all the time, and this is why we've followed this process. I'm sure as a reference, Your Honor, we've identified what portions of the statements we seek to introduce, and it's incumbent upon the defendant.
And that was done when?
In December, Your Honor.
No, and the identification of the portions that you want to introduce.
Through these transcripts, that's what we did. We just boiled it down to
so
this is
what
the
date
universe.
was that?
They were provided that at the end of the month of December.
Your Honor, if I could just
okay, I'm confused.
I think I can
one is whether they were boiled down, and 2, whether they were provided the entirety of the transcripts of all the jail recordings.
We've never provided an entire transcript. We don't have an entire transcript.
So what was provided in December were these very things now, and maybe additional ones, or?
I haven't given the court every single one we've provided to defense counsel.
Okay, so these were provided, the ones I'm looking at now were provided in December.
Correct.
And they may be untranscribed, that the Commonwealth had no interest in transcribing, and so obviously
we've listened. We've had an assistant district attorney listen to those calls and make notes and all those things, and we've assessed them and we've provided what we say we.
So whatever has been transcribed, is it fair to say that whatever has actually been transcribed has been provided, or only the smaller group of the things that were transcribed that you're actually seeking to introduce?
That we have official transcripts of, we provided. We have not provided the assistant district attorney's notes.
Right, thank you. Let's do the next one. And if you could just tell me the date before we do that. That's
sure.
The one that begins with Tanya Singleton saying Shayana.
The next call between the defendant and Ms. Singleton, Your Honor, is July 23rd.
Thank you.
And that's laid out on page 13 of my memo.
Yes. And the relevance of that one.
This, Your Honor, includes statements by the defendant regarding a trust fund for...
No, this is Shayana, he's real good.
Oh, I'm sorry, Your Honor. You're referencing now what the defendant has indexed, is that correct?
Yes, I'm only dealing with
And
conversations now in which Mr. Hernandez is a party. And the number 4 is the I miss my uncle.
I'm sorry, Your Honor?
The I miss my uncle one?
Your Honor, what I boiled down even further is how we would actually seek to introduce them. So to the extent that the defendant has annexed them, we're not looking to put every single one of those calls.
Okay, so is this one you're not seeking to put in?
No, as I've identified, I think in my memo, we've continued to try and just refine it based on the issues as
Right, so I just want an answer. So this one is not one you're seeking to put in?
not independent of a witness, Your Honor. So I guess...
What does that mean?
Meaning this, we've indicated we would be interested in some circumstances of putting in just a phone call without a witness, right? But of course, sometimes there may be circumstances in which the witness is on the stand where it becomes relevant, and so we're not trying to...
Right, so if Ms. Singleton is called and testifies, something may become relevant.
Right, and
or
so...
Or the defendant takes a stand.
And what I've tried to focus in on, Your Honor, is just as a recording, could the Commonwealth introduce it as a standalone?
So you're not seeking that one which begins with Tanya Singleton, person identified as Tanya Singleton saying Shayana, Shayana.
Right, Your Honor. As I've indicated...
The next one is the setup, the trust fund, the date of that is?
July 23rd, Your Honor.
Your argument on that one?
As you've heard, regarding monies, that the defendant was then providing prior to Ms. Singleton's appearance and her contumacious conduct at the grand jury, Your Honor. The defendant on July 23rd is indicating to her, Ms. Singleton, that he was going to be setting up a trust fund, or I set up, not in the future, but as he indicates to her, it's either $75,000 apiece or $100,000 apiece. He's in fact not sure, and he indicates a number of things about that, they'll have essentially millions of dollars when they reach the age of majority, Your Honor.
Your Honor, as argued in our motion, we believe that the conversation lacks relevance, as it's a conversation between two relatives about the continued support. This is Mr. Hernandez, who has been charged with a serious crime. He's incarcerated or being held without bail. Obviously, there is a relationship between pre-existing relationship between Mr. Hernandez and Ms. Singleton and her boys. And he's talking about something, by the way, which never occurred. And further, Your Honor, I think this snippet is instructive on page 3 of the nature of the relationship and any support that traditionally has been provided to Ms. Singleton, where Mr. Hernandez says, don't tell anybody. I don't want anybody to know about it. I ain't even telling my girl. Nobody. Clearly, it's an indication, we believe, of an individual who's trying to keep financial affairs private, trying to help out a terminally ill, stage 4 metastatic breast cancer patient who has 2 young boys. And he's talking to her about his intention to attempt to help with that. An intention that was never fulfilled. And again, Your Honor, it's a classic example of how this could, in the way in which it's being represented to the court today, confuse a jury and invite a jury to speculate. And may I add, there is no evidence before this court in this trial of Mr. Hernandez procuring the contumacious conduct, I believe was referred to by Ms. Singleton. None that would indicate that that was arranged, or I think the word the prosecution uses is orchestrated, or anything other than an individual decision made by Ms. Singleton on her own. And I think to link that to this conversation is fanciful, and we would ask that it be excluded.
Well, of course, Your Honor, it's up to the jury to decide what the reasonable inferences are, but you have this stage 4 metastatic cancer patient who essentially takes off from her treatment to flee to Georgia with the co-defendant, Ernest Wallace, who buys a burner phone, who makes the arrangements for the trip down there, provides support for the co-defendant, comes back and maintains contact with the co-defendant, which we have ample evidence of in these telephone calls, wherein they're talking about a number of things, including being silent and hanging together, evidence of a conspiracy to conceal the crime. And then we have these conversations as the defendant concedes. He says, I set up an account, and lo and behold, he didn't. So here we have this person who says he's so generous with his money and providing support, and he can't name the number, right, of the account that he has set up. He can't assign the value to it. He's talking to her in order to secure her continued loyalty, and we know he knows she's going to be held in contempt, because when we get to the August 1st telephone calls, when he speaks to Shayana Jenkins, and Shayana says that Tanya's in custody, he says, initially he's a little concerned, I believe, if you take from the context, because he thinks she's been arrested and charged with a substantive crime. He gets off the telephone, he goes and does whatever he does. He comes back and he says to Shayana, I knew that. So, and he's well aware that she was going to be held in contempt ahead of her actually going to the grand jury. So it is not speculative. It is a reasonable inference, and it is up for the jury to determine whether that's a reasonable inference. It is not that the defendant has a unilateral position that has to be accepted by the jurors. He suggests that it is out of the goodness of his heart that he's misleading his cousin into thinking that her children are going to have millions of dollars when they turn 18. I don't believe that that is a reasonable inference. And so the Commonwealth's position is that this is a step in the road to securing the conduct that then occurs at the grand jury.
The Commonwealth's ability to engage in imaginary behavior knows no bounds, Your Honor, and this is exactly what they're trying to encourage the jury to do. They are not encouraging reasonable inferences. They are not encouraging any evidence-based conclusions. They are instead trying to ascribe meaning to words which obviously have multiple meanings, including the future transcript, which I believe we'll get to, where he says, I knew that. Once again, we have the use of the word that. That could mean I knew she was in. I knew she was confined. It doesn't mean that he knew in advance or planned in advance her contempt before the grand jury. That is pure speculation, not a reasonable inference, Your Honor, and precisely the type of prejudicial speculation that the balancing encouraged by Commonwealth v. Spencer discourages and prohibits.
Unlike some of the other transcripts where I assume the district attorney or someone has identified for the stenographer the women's voice, this one does not. Has this one been, is there a way to?
There is, Your Honor, based on the record of the call as well as the reference, which is misspelled here, to the two children. You'll recall yesterday Ms. Mercado identified Ms. Singleton's two children, two
right,
sons.
but he could be telling someone else about it.
But it's also consistent with the number that he called, that it's Ms. Singleton. And I believe, Your Honor, on the issue of authentication, I believe we would be...
We'll deal with authentication
yes,
overall, but just on But just on this one, I was just curious whether you think it can be authenticated to her.
Yes, Your Honor.
The next one, checking out the little kid I used to chill with.
Your Honor, I moved to the August 1st.
Okay, so the Commonwealth is not seeking that one. Again, unless someone opens the door to it.
Exactly. I guess to say maybe we reserve our right, but we're seeking to put that in affirmatively at this point.
And the Pouncey one also not?
Correct, Your Honor.
That's 7, is that correct, Your Honor, that your quote's referring to? Good at 7?
Yes. Then you remember Dark Knight?
Correct, Your Honor.
And not seeking that one?
Correct, Your Honor.
The throwaway phone?
Correct, Your Honor.
Not?
No.
Right. I just want to make clear when you say correct, you're not seeking that one?
Correct, Your Honor. I believe that the next one that
is the next.
Index 11 and 12.
Did you hear about the Range Rover?
No, Your Honor. No.
The next one, Tanya's in jail?
Yes, Your Honor.
And the date of that one is?
That's August 1st.
Thank you. He won that.
Transcript is identified by the defendant as number 11, Your Honor, is now Ms. Jenkins providing the information to Mr. Hernandez that Ms. Singleton has been taken into custody. She told me to tell you that she's going to be just fine, to keep your head up and to know that she loves you. And then the defendant, let me call you right back. And then the next two transcripts are actually the defendant calling right back, Your Honor. So
and once we get beyond the information that Tanya's in jail, the first line, what's the relevance of the rest?
Well, Ms. Jenkins has been asked to communicate a message to Mr. Hernandez, and she does that. I think it's important in the Commonwealth's position, Your Honor, is that beginning at the time of the arrival of the police on June 17th, and I don't want to belabor the point, and if the court doesn't want me to do that, I won't, Your Honor, but the telephone calls begin from Mr. Hernandez at 9:47. You'll recall, Your Honor, the police arrive at approximately 9:45. And so in that 40 minutes that the defendant is in his house watching the police try and raise him from the interior, he starts essentially executing a cover-up of this crime. And he involves Ms. Jenkins, and he involves Ms. Singleton. It is in concert with Mr. Wallace and Mr. Ortiz. You'll recall, Your Honor, we have had some evidence, and we will have further evidence of where Mr. Wallace and Mr. Ortiz go that night. They drive back.
This statement, though, that you're trying to get in, that she told me to tell you, is really double hearsay, right? We have the hearsay statement by Ms. Jenkins, and then she's purporting to recite what someone else told her, all coming in for the truth of the fact that the other person actually said that.
Correct, Your Honor. And of course, each step in totem pole hearsay has to have an exception if it's offered for the truth. To some extent, Your Honor, it doesn't need to be analyzed that way because it is simply bears on the defendant's state of mind to keep his head up, not to be concerned about Ms. Singleton. But to this extent, each of those participants in the hearsay portion of the statement, Commonwealth contends, are co-conspirators in the cover-up of this particular crime. And we have to prove that, Your Honor, simply by preponderance of the evidence. We don't have to even have direct evidence of that. There's a number of cases, obviously, in the Commonwealth on the issue of our burden that I would cite to the court,
Right.
Your Honor. Do you want me to proceed on
No,
that?
I don't think there's any disagreement that the foundational prerequisites need to be met by preponderance of the evidence.
We're at a legal standard here.
Right, and I'd cite the court specifically to among others, Beal, Commonwealth versus Beal, 314 Mass 210. It's not essential to a conspiracy that the parties meet or they confer or formulate their plans. Common purpose may be inferred from concerted action converging to a definite end. And here, there's ample evidence of the definite end in that it is all about covering up the homicide, the murder of Odin Lloyd. And Ms. Jenkins is involved in that, Ms. Singleton is involved in that, and Mr. Hernandez is obviously involved in that. And as evidenced by a number of facts, Your Honor, beginning, not just beginning, but particularly, you've seen the video of them acting in the house on the day of June 17th, the telephone calls, the manner of the flight, the fact that they then, Ms. Jenkins herself meets with, I'm going to suggest a reasonable inference, withdraws money in Rhode Island, provides that to Mr. Wallace and Mr. Ortiz. And so all of those things, that now bear on these particular telephone calls and what is being communicated back and forth between the parties, Your Honor, I'm suggesting that they meet the definition of co-conspirators. And each leg of the totem pole hearsay in this particular case are statements attributed to co-conspirators. And so when that's communicated to the defendant on August 1st, that's consistent with it being done in furtherance of them continuing to cover up the crime.
Well, Your Honor, we kind of got a feel from the transcript here, but what I would say is it sounds like the Commonwealth is describing a crime with which Mr. Hernandez has not been charged. Some type of a conspiracy or to obstruct justice or some type of a conspiracy to impede the flow of information. That is not the joint venture with which he's been charged, which is the joint venture relating to the murder of Odin Lloyd with two other individuals. This is all add-on, which we think, as we have argued in our submission, Your Honor, the court has to look at the conversation partners that are dealing with an individual to whom the admission theory could apply, has to look at those as a source of hearsay. Here we have double hearsay. There is no finding along the lines of what Mr. Bomberg is advocating for, to my knowledge. Furthermore, Your Honor, looking at the substance of this communication, Mr. Hernandez, Tanya's in jail for what? He says. It seems to be quite inconsistent with what Mr. Bomberg argued a few moments ago about Mr. Hernandez somehow was pulling the strings on all this and knew in advance about her potential contempt, which would result in confinement. So it's completely internally inconsistent with what they're advocating for, and I believe it also shows, not only because of the hearsay, which we think the court has identified appropriately as double hearsay, but we would also indicate, Your Honor, this is a grounds for speculation and for the jury to engage in unwarranted speculation, unreasonable speculation, and resulting in confusion.
I don't understand how it could be speculative because at 6:30 in the evening now.
Okay, so the next one is also 8-1.
Correct, Your Honor. 17 minutes later, the defendant and Ms. Jenkins are again on the phone, and the defendant says, "Hey." Ms. Jenkins says, "Yeah." Mr. Hernandez says, I knew about. Ms. Jenkins says, huh? I knew about that. I thought it was, and then you can't make it out. And Jenkins says, I'm just letting you know. So he says in the phone call before, let me call you right back. He goes, he does whatever he does, and he calls her right back, and he says, I knew about that. And I think that the evidence suggests that he had been concerned that she would be charged with a substantive crime, but that he was well aware that she was going to go to the grand jury and not speak, because as the call continues, he describes his own understanding of contempt. Yes, they just being asses about it, but they got to go out of their way to be assholes, and like the longest she'll do is like probably less than a month, or a month until the grand jury is done. Investigation, do you know what I mean? And so to suggest that he didn't know about it, he's the one that's providing the information. So I'm suggesting to the court that the reasonable inference is that he's quite aware of it beforehand. He didn't know exactly, based on what Ms. Jenkins had said in the first call, whether it was that or something else. Tanya's in jail, I don't know, so she's in jail. She got arrested today, and he says they picked her up by her house, question mark. No, she was, I don't know, you probably should.
Why is his asking questions, they cuffed her up, question mark, a reflective of constant guilt? Or I think she's not going to be over here with me, presumably Dartmouth House, conscious of guilt.
You'll see, Your Honor, in my filing, I have omitted that portion of it. Do you see what I'm saying? I filed sort of very, as the court asked me to, call by call, very discreet.
Well, I originally asked you to provide to the defendant, call by call, the specifics you wanted in, so that they could file a brief and I could see it.
Right.
Not that it would come in the...
Well, we gave them, as you know, Your Honor, ahead of time. If we don't give it to them and later something arises, we try to be as cautious as possible. When I filed this, I've edited it down to what I think is relevant.
So it's only the statements in the Commonwealth's opposition that you're seeking to get at?
Independent, yes, Your Honor, as I described. And that's, I understood that's what you had asked me to do, Your Honor.
Well, Your Honor, I mean, that's a further fragmentation of a larger set of conversations. That certainly wasn't clear to us as we read the Commonwealth's opposition, that it was further excerpting excerpts, which, Your Honor, I just don't want to belabor the point. The further excerpting of excerpts means that statements are taken further out of context and have the tendency to mislead the jury.
I wrote on page 10, Your Honor, applying these principles, the Commonwealth seeks to reduce portions of phone calls as follows.
Right.
Hold.
The next one being the only good thing about Tanya is she's going to lose weight?
Correct, Your Honor.
The date of that is?
Yeah, the same date, same call.
And
August
the
1st.
And the relevance of that is?
It expresses an indifference to this alleged plight of Miss Singleton, the stage 4 cancer patient that somehow she has been put upon by the government in holding her in contempt. The defendant evidences his own disregard for her health, in his own lack of concern for the fact that she is doing exactly what is the object of this agreement, which is to withhold information.
Thank you.
I hesitate to even dignify that with a response, but we just heard that there's a relationship and he's giving her money in order to procure her silence. Now he's got indifference toward her. It makes absolutely no sense, and it is not relevant.
Well, the defendant has used a number of means. Some of them are outright false, telling her she's going to have money for her children and then not doing it. He's engaged in every scheme possible to ensure her silence.
The next one that begins, hey, how's Tanya?
Yes, Your Honor. That's a call between the defendant and his mother.
And the date of that is?
August 2nd, the following day, in the afternoon, Your Honor.
The relevance?
Again, Your Honor, showing the defendant's own view of what's going to happen to Ms. Singleton and his own understanding of her conduct at the grand jury.
Mr. Fee, did you want to respond?
Your Honor, I would only note that in the earlier transcript, which is Exhibit 11, when the news is broken to Mr. Hernandez about Ms. Singleton having been arrested, Ms. Jenkins, and I'm not conceding the admissibility of this hearsay statement, but as read in court today, Ms. Jenkins states, no, she went, she was, I don't know, you should probably talk to your lawyers about it. Oh, but she told me you were going to be just fine. Oh my God, let me call you right back. Something happened, Your Honor, and we don't see the transcript of any call or any action that Mr. Hernandez took in between, but he appears to be educated now about some of the possible implications of criminal contempt. And I think it's bizarre to impute that knowledge of having been in Mr. Hernandez's head all along, that he is some kind of an expert who has figured all of this out on his own. So again, an excerpt of a conversation between a jail defendant and his mother about a beloved cousin is not relevant, number one, but number two, even if it passed the relevance test, would clearly fail under the balancing test endorsed by Spencer.
Well, the defendant's own words, they can only hold her for like a month or till the investigation's over, so that ain't nothing. I guess we have to accept, according to the defendant, that this is the beloved cousin that he's speaking about, but it doesn't appear that he's too concerned. And the fact of the matter is, the defendant's own words were that he knew ahead of time. He knew that that was going to happen. So to suggest that there's some other factual circumstance is belied by the defendant.
I can only say that's an absolute reach, Your Honor, and can only be an attempt to try to use this evidence to somehow bolster a founder in case in chief. It is not relevant. It does not have any obvious or clear meaning and would cause the jury to speculate and confuse them.
For next, the conversation with Mr. Pouncey.
No, Your Honor, I'm not...
The next one that begins, I want you to do me a favor.
Yes, Your Honor.
And the date of that one is?
August 3rd. That's a call to Ms. Jenkins, Your Honor.
I'm hearing that.
The defendant begins by asking Ms. Jenkins to do him a favor. She says, all right, can you give him, somehow stop by Tanya's house, give them a little bit of money to put on her canteen. Babe, I'm not going over there. I'm not going over there. Oh, well, send her money or something. And she says, I don't know why you keep, she's got no money in jail. And Ms. Jenkins, I understand that, but why do I have to keep being the one to do that? That's what you're not understanding. Can you give it to him? I don't know who to tell you to give it to. Well, neither do I. All right, I'm trying. Well, I'm trying to follow what my lawyers are telling me to follow, and then you keep trying to have me do other things. That was Ms. Jenkins' response, Your Honor.
I haven't heard anything, Your Honor, that would indicate that this is a conversation that is a relevant conversation. Number one, clearly they're offering Ms. Jenkins' statement as a conversation partner for the truth of the matter, so that would require much deeper and further analysis. Second, the conversation itself is a conversation between Mr. Hernandez and Ms. Jenkins in which he doesn't order her to do anything. He makes a request. He asks for a favor. And I think there's evidence before this court, as recently as yesterday, as to the genesis of that. This is canteen money for an individual who doesn't have money of her own, and he makes a request. And Ms. Jenkins appears in this snippet of the conversation to decline. And that's the end of it. There's nothing here in this conversation that would be relevant evidence in this case, and again, has the likelihood to confuse and mislead the jury.
She resists, but...
Well, I thought she was a willing co-conspirator that would do anything he asked. I mean, this is really stretching the lines of relevance, Your Honor, to a point where it's dangerous.
Well, as you know, Your Honor, a co-conspirator doesn't have to do everything they're asked to still be a willing participant in the conspiracy. There can be a give and take. She resists. Ultimately, we know that, in fact, the money is provided. We've had evidence of that. And so when we begin on June 17th with the defendant telling Ernest Wallace, his co-defendant, to keep his phone on and call Shay, the fact that that's a continuation of the defendant using Ms. Jenkins' phone the night before, the fact that when they're there later, when the defendant goes to the police station, he's directing all of these participants as they're out there now interacting with people. As you will recall, Your Honor, Ms. Jenkins said she was going home with her child from the police station, and she doesn't, because she goes to the apartment in Franklin, and there's ample evidence of that from her cellular telephone location. Then she goes down to Coventry, Rhode Island. At the same time, Mr. Wallace and Mr. Ortiz are coming back to Coventry, Rhode Island, and she withdraws the $500 from the ATM, which we had the Webster Bank representative discuss. Then she comes back to the house. She the next day, at the direction of the defendant, the evidence is going to show, disposes of the items, which we've already seen her doing by coming out the back of the house. When she's asked about that, she has no memory of where she actually went and disposed of those items. That she continues afterward, Your Honor, at the direction of the defendant, as he says to her to get her to do something for him, and she says, "I'm trying to follow what my lawyers are telling me to follow, and then you keep trying to have me do other things." There's ample evidence that the Commonwealth has satisfied the standard.
Well, you can't use the statement to satisfy any standard.
Correct, and that's why I've detailed all those other things beforehand, Your Honor. I agree. The statement itself can't be the means by which the Commonwealth carries its burden, but all of those other portions that I have identified, Your Honor, leading up to that, plus, I mean, I tried to do that in a summarized fashion, Your Honor. There's ample evidence that she was acting in concert with the defendant, and so she responds.
Thank you. The next one, did you write her?
May I just have a moment, Your Honor? I'm sorry. Is that identified as number 17?
17, yes.
Yeah, no, Your Honor. The next one is identified as number 18. That's September 7th of 2013, Your Honor. A call to Ms. Mercado. And there, the defendant indicates that he's now enlisted his agent to provide money, $500.
Your Honor, I'd only note that Ms. Mercado's statement, this is a hearsay statement. I haven't heard any theory that would allow the admission of Ms. Mercado's statement. And again, I think along the same lines as which I've established before on any of these references, assuming the hearsay barrier were overcome, this is an innocuous conversation about the support of an incarcerated relative who apparently Mr. Hernandez now has lost his indifference for and loves.
Well, I said he's indifferent to her condition. I didn't say he's indifferent to whether or not she continues to be silent, because he clearly is not indifferent to her continued silence.
20 with Mr. Pouncey?
No, Your Honor.
I'm sorry, 19, Your Honor, did we?
Oh, I'm sorry, that meant 19, I'm sorry, 19.
That's Ms. Mercado again,
With
Your
Ms.
Honor.
Mercado.
No, Your Honor. No.
20 with Mr. Pouncey is no.
No, Your Honor.
21,
No, Your Honor.
I'm sorry, 21 is no.
Two.
That's the December 25th, 2013 call. It's 7:30 or thereabouts in the evening, Your Honor. This would fall into the category, Your Honor. I don't know that we would be admitting this or seeking to admit this affirmatively absent Ms. Jenkins on the stand, but I do think it's going to be the subject of examination.
So, but for today's purposes, I don't have to rule.
Yeah, correct, Your Honor. For today's purposes, I don't think we need to deal with that.
23 about the rented television?
No, Your Honor.
The next the transcripts that deal with conversations between persons other than Mr. Hernandez. And I know first, I think the defense has a legal argument with respect to all of them. And you might deal separately with...
I'd like to, Your Honor.
But separately with... We'll go through each recording separately, but your legal argument, you might deal separately with respect to Ms. Singleton, Mr. Wallace,
Yes.
and to the extent there are any, Ms. Jenkins.
It's the way we arranged it in our submission, Your Honor, and it's the way I'd prefer to do it. First, let me speak regarding the conversations to which Mr. Hernandez is not a party. These are recorded jail conversations between Mr. Wallace and other persons. And I would note, Your Honor, at the outset, that this issue raises a very serious issue under the Confrontation Clause because they are out-of-court statements that would be made and about which the defendant would be deprived of his right to confront and cross-examine. And for that reason, there is a very limited exception to the hearsay rule, very limited exception, premised on joint venture and premised on the statements of co-conspirators. And this is, in Massachusetts, well-settled law. As it relates to Mr. Wallace is a co-defendant of Mr. Hernandez. This is being separately tried. And a theory has been espoused relating to joint venture between Mr. Hernandez and Mr. Wallace as it relates to the murder of Odin Lloyd. Your Honor, that joint venture has to be established by a preponderance of the evidence that would be submitted to this court. And I'd like to just move on to what I believe is the dispositive issue as it relates to joint venture with Mr. Wallace. And that is assuming that a joint venture is declared based upon the preponderance of the evidence. Then the question becomes, can Mr. Wallace's statements be admitted against the defendant in this trial? And the law, Your Honor, in Massachusetts, going back to Bon Gorzone and other cases, states that those statements have to be made during the pendency of the criminal joint venture, and further have to be made to further the joint venture. And that's a recognized exception to Massachusetts for the statements of a joint venturer. However, Your Honor, what the Commonwealth advocates in this case appears to be unprecedented in that this joint venture never ends. It continues perhaps to this day in the eyes of the Commonwealth. And Your Honor, because this is an exception to the Confrontation Clause and the rights to cross-examine a witness, this exception has been policed by the SJC very, very vigilantly. And there is a large body of law, starting with Commonwealth v. White and Bon Gorzone, and that states that statements of a co-conspirator or a joint venturer cannot be used after the joint venture has terminated. And what's interesting here, Your Honor, is that there is a clear body of case law in which the SJC has categorically declared that the joint venture ends with the apprehension and detention or imprisonment of a co-venturer, because the fundamentals of the exception are no longer there, the community of interest and furtherance of the crime. Here it is alleged that there is a joint venture to murder Mr. Lloyd. All of these communications that Wallace have been transcribed occurred when he was in custody. Your Honor, under the line of cases from the SJC that have been brought current right up through 2013 with the Santos case, the SJC has declared that the joint venture ends when the defendants are apprehended. Now, Your Honor, the Commonwealth asked this court to fashion a new rule. The Commonwealth asked this court to declare that the joint venture started, I'm not sure whether it was before the murder, but today I heard maybe it was after the murder, but that the joint venture continues endlessly. And that's just simply not supported by any case law. The case law they gave you, Your Honor, is very, very interesting. And I'd like to just make note of what they cited to you. In order to encourage this court to fashion this new law and to go contrary to Santos and to go contrary to Drew and to go contrary to other cases in which the SJC has declared that the joint venture ends, they craft a theory around the Commonwealth, or the SJC's case in Commonwealth v. Angiulo. And here what they're saying is that, no, this joint venture doesn't end when they're apprehended. This joint venture continues when they're apprehended, and there's no end in sight. It continues apparently to this day. The authority they cite to you, Your Honor, is a quote from Commonwealth versus Angiulo. And in the Angiulo case, there was a joint venture among some organized crime figures to kill someone. They killed him. And then while they were outside, they were overheard on recordings that were made by prosecutors and police to be talking about the murder of that individual and trying to conceal the murder of that individual. Shortly after the murder, while they were free, the Commonwealth cites this case, and in particular, Your Honor, they put a quote before you on page 6 of their brief that says, quote, efforts on the part of a joint venture to conceal the occurrence of the enterprise's unlawful purpose or to effect an escape warrant the inference that the joint venture continued through the time the statements were made, period. Citing, that's Angiulo, citing Commonwealth v. White, Ibid. They then go on to discuss. Your Honor, that quotation that they gave you is cited for the prospect that apprehension and detention does not terminate the joint venture. Well, if one looks at the actual citation that is present in Angiulo, the court continued. After stating the statements were made and citing Commonwealth v. White, the Supreme Judicial Court goes on to say, absent a circumstance such as where the declarant had been incarcerated at the time of the statement was made, as was the case in Commonwealth v. Drew, or where the declarant has been apprehended before the statement has been made, as was the case in Commonwealth v. Dahlstrom. There is nothing about the Angiulo case, Your Honor, that undermines the SJC's clear and definitive rule articulated as recently as Santos, which states that when a co-defendant or a joint venturer is apprehended, this narrow exception to the hearsay rule and this narrow undermining, if you will, of the confrontation clause ends. It's over. And it cannot continue endlessly. And I think the citation of that authority, Your Honor, to this court speaks volumes about the quality and the integrity of that argument.
And sort of with respect to
Ms. Singleton?
Ms. Singleton and
I would say with
Ms.
Ms. Singleton, Your Honor, I would allege that Ms. Singleton, again, there has been no finding by this court, by preponderance of evidence, that Ms. Singleton is a joint venturer in this crime to murder Odin Lloyd. And Your Honor, all we've heard today may be a separate crime, but that's not the joint venture to murder Odin Lloyd. It's just simply not the case.
But if there is sufficient evidence to infer by preponderance, sufficient evidence by preponderance of the evidence that she conspired with Mr. Hernandez to cover up the crime, and that the conspiracy was specifically with Mr. Hernandez, and that these statements were made in furtherance of the conspiracy.
Then I would say they would be admissible in a case involving a conspiracy to obstruct justice or to in some way cover up the crime, but they should not be admissible in a murder trial, especially given the length of time that has elapsed, especially given the apprehension of the alleged three venturers. The fact that she's not charged as a co-defendant in this case, I think, is also relevant. But I think, Your Honor...
And she was also in custody when these...
She absolutely was in custody when these were recorded. Otherwise, they wouldn't have the recordings. Now, there are some recordings of Ms. Singleton with Mr. Hernandez, I believe, where she's not in custody.
Right. I'm talking about the...
Correct. But all of her recordings are when she is in custody as well. So, again, I would say that the termination language that is definitive and categorical out of the SJC applies. I don't know if I need to spend much time on this, Your Honor, but in the Commonwealth submission, they raise a new argument where they say that Ms. Singleton was the defendant's agent. And therefore, there's an exception to the hearsay rule regarding agency admissions. The case they cite is a civil case in a negligence action involving the statements of an employee which were referred back by the appeals court to the Superior Court for a finding on whether or not the two predicate requirements for the admission of agency statements in a civil action were satisfied. Number one, whether the declarant was authorized to act on the matters about which he spoke, and then second, whether the probative value outweighs the potential unfair prejudice. I find that theory completely inapplicable here, Your Honor, to a criminal case. It has no implications for the confrontation clause. There is no evidence that Mr. Hernandez made Ms. Singleton his agent or employee in order to trigger this exception. I don't know if the court wants me to address that any further, but I do not believe that is applicable here at all.
Well, if one actually was an agent, I mean, the rules of evidence generally, absent some special constitutional issue, applicable to civil and criminal. So if one actually was
an employee, an authorized employee,
an authorized agent making a statement in the course of their authorized duties, would that be admissible against a principal? in a criminal case?
Yeah, I believe it would, absent another layer of constitutional scrutiny, Your Honor, in terms of the implications for that under the Confrontation Clause, and whether or not those declarants were available to testify in court or not. And I further, obviously they would be subject to a 403 type balancing before it ever came in. But I saw no criminal case cited by the Commonwealth. I saw a Massachusetts Appeals Court case called Thorell relating to a negligence action. So I would state, Your Honor, that I would, just to conclude, on Ms. Singleton, I do not believe that there is a sufficient basis for statements made by Ms. Singleton while she was incarcerated to be qualified under the joint venture exception. I would also note that there is no finding that Ms. Singleton was a co-venturer as it relates to the murder of Odin Lloyd. There is apparently a separate field of activity that the Commonwealth is focusing on. That's not the joint venture relating to the murder of Odin Lloyd. So I would say, Your Honor, for all of those reasons, both the statements of Mr. Wallace and the statements of Ms. Singleton should be excluded.
And are there any of Ms. Jenkins to anyone else other than to Mr. Hernandez?
I'm not aware of Ms. Jenkins. I haven't seen any proffered recordings or transcripts, excerpts relating to Ms. Jenkins other than the ones we've discussed.
And is your argument on the substantive use of Ms. Jenkins's statements with respect to Mr. Hernandez the sort of the same as you made with respect to Ms. Singleton, her non-custodial ones, or the...
Yes, Your Honor. Yes, Your Honor. I would say that there is no finding that she is a co-venturer whose statements would be eligible for that finding, and in the absence of her status as a co-venturer in the murder of Odin Lloyd, as a co-venturer as it relates to an uncharged crime, I would say that those statements are not admissible. And further, they are without that exception. They are classic hearsay statements.
Why would they not fall under if the Commonwealth can make out a preponderance of the evidence that she was engaged in a conspiracy with him, specifically to hide evidence or to facilitate the, in effect, being an accessory after the fact, a conspiracy with him to do that?
To my knowledge, neither she nor Mr. Hernandez is charged with that. And I would say that is not relevant and not admissible in this first-degree murder trial.
Thank you.
As the court well knows, the existence of the charge isn't a predicate for a finding of conspiracy. That's just simply not the analysis. So to suggest that no conspiracy that is designed to conceal the substantive crime can exist because no one is charged, that's not the analysis. And I think that that's what the defendant is suggesting. Absent a charge, you can't have the evidence, but that's not the analysis. The analysis is, just as the court has laid out, and just as the Commonwealth has argued, whether by a preponderance, the Commonwealth has proven that this concealment conspiracy, a conspiracy designed to conceal the underlying crime, which is not a novel theory, exists. And the defendant says, in addition to the fact that you need the charge, which you don't need, that Ms. Singleton was in custody when she spoke to Mr. Wallace during the course of these 4 telephone calls that the Commonwealth has laid out in its memo from page 10 through 14.
Separately.
Well, she's not it's factually incorrect. She's not in custody. And so to the extent that the defendant relies on that, it's just factually not correct. So in the Commonwealth's view, Your Honor, and this is what we're suggesting to the court, the standard is there a preponderance of the evidence that these individuals were involved in an agreement to conceal the murder of Odin Lloyd? Mr. Wallace, who's a co-defendant in the underlying murder, then, Your Honor, the conduct between he and Mr. Hernandez, he and Ms. Jenkins, he and Ms. Singleton establishes, as has been laid
But
out.
she could have been involved in a conspiracy to conceal with Mr. Wallace and not have conspired. And it may be that a conspiracy with Mr. Wallace would materially help Mr. Hernandez as a byproduct, but it doesn't, wouldn't automatically follow that she...
Your Honor, I'm not saying that that's the only explanation, but we don't have to show that that's the only explanation, right? We can show that it's a reasonable inference that she is. She is the defendant's cousin. She is the site of where Hobo lives, right? She is the site from which he departs and to which he returns. And then she is the person that assists. And you've heard that there isn't any money involved here, Your Honor, right? Miss Singleton is not a wealthy person. Mr. Wallace, who essentially stays with her, stays with the defendant, he's not a wealthy person. There's evidence that there is money being funneled to them by the defendant, right? So all of that in your analysis of what is the conspiracy, who is involved, who is benefiting, and who is providing the resources, all of that, Your Honor, makes the reasonable inference that it is these individuals who are involved in concealing the murder of Odin Lloyd by fleeing, by hiding evidence, by doing a number of things in the back and forth that is continuous. And obviously the court has in evidence the telephone records of these individuals.
Right. Should we go now to the specifics?
Sure, Your Honor, because there's 4 calls that the Commonwealth seeks to reduce.
So the first one is the one that begins, wait, with Mr. Mikado. I'm just doing the order in which they were
Are you
handed
doing
up.
the Singleton calls, Your Honor, first?
Yes.
Thank you.
No, Your Honor.
Okay. I'm doing the order in which they were handed up by you to the clerk. So.
I was just trying to be responsive to what I understood the request, but I've laid out 4 calls in the memorandum.
Okay, so let me just go through and see, are you seeking to get in the Tanya Singleton to Mikado saying,
No, Your Honor,
wait.
I think
No.
No.
Okay.
And again, Your Honor, that's, again, I'm talking about,
Right.
we've had Ms. Mercado here, and there's been some testimony, and I don't think, independent of that, we're really looking for further discussion between her
And the next one is also Mikado with Tanya Singleton. You're
No,
not
Your
trying to get
Honor.
out.
No, Your Honor.
And the next one is also Mikado and a little child voice. You're
No.
not trying to get out.
No, Your Honor.
And the next one also Mikado, no, right?
Correct, Your Honor.
And the next one's also Mikado, no.
No, Your Honor.
And the next one's also Mikado, is no.
No, Your Honor.
And the next one is Wallace and Singleton, Utel Inc. I love it.
Correct, Your Honor. That's a call that's
And the date of that call?
July 12th.
And at that point, Miss Singleton is not incarcerated, right?
Correct. Mr. Wallace is an inmate being held pre-trial. Ms. Singleton is not, Your Honor. And
I'll hear you on the relevancy of that, assuming the court rejects the defense argument that as a matter of law, these are not admissible.
what you'll find, Your Honor, is that Mr. Wallace is asking Miss Singleton to convey to Mr. Hernandez, you tell Inc. I love him, man. Tell Inc. I love him. Tell him no matter what, man, don't think I'm lying. I'll never go against the grain, you hear me? And I think that it is a reasonable inference for the jurors to conclude that Mr. Wallace is asking Miss Singleton to convey to Mr. Hernandez that he's not speaking, that he himself is loyal and he will continue to conceal the crime. Tell him we gotta work together. Tell him we gotta work together.
Thank you.
Your Honor, I would just note that in Commonwealth versus Bongarzone, the SJC approved of an instruction by a Superior Court judge to the jury, quote, that as a matter of law, any joint venture terminated with the arrest of Smith and Trent. Again, I won't repeat my argument on termination. I think this is divining from this snippet of a conversation. Again, we don't have the full conversation for reasons I've stated with respect to others. I believe it should be excluded, but I don't in any way want to undermine or in any way waive the arguments I've made previously about the termination of a joint venture and the complete inadmissibility of this call while Mr. Wallace was incarcerated.
Thank you. The next one, Wallace and Singleton, the date of that one is?
July 17th, Your Honor.
And Ms. Singleton is also not incarcerated?
Correct.
Yes. Relevancy.
Miss Singleton says to Mr. Wallace that she has spoken to Prince. He said, you and him all the way, you know. She's telling that to Mr. Wallace. She's conveying the message from the defendant to Mr. Wallace. Mr. Wallace says, all right, I love that nigga man. Miss Singleton, he love you too. Mr. Wallace, I'm riding. Miss Singleton, that's what he said. Mr. Wallace, I'm riding. You know what I mean, I'm riding. And she says, yeah, that's what he said. And then it indicates that Mr. Wallace says, la la la, got us all into this, man. They gotta know. And Miss Singleton says, I know, yeah, it's gonna be fine. I'm gonna call your lawyer today. And I think, Your Honor, it evidences the close cooperation between Miss Singleton, Mr. Wallace, and Mr. Hernandez in sticking together in furtherance of their concealment conspiracy.
Relevance, Your Honor, and again, the 403 balancing. Mr. Baumberg's interpretation of what these individuals are saying, I think is not the only interpretation of what they're saying, and I believe that it has the tendency to confuse and mislead the jury, cause them to speculate precisely the type of prejudice that was recognized in Commonwealth v. Spencer.
The next one,
Yeah.
Wallace, talk to Princess.
Talk to Princess
The date of that one is?
is July 19th, Your Honor. And Mr. Wallace is asking Miss Singleton to speak to Princess, who is, as we know, Miss Jenkins. Ask her if she can tell my nigga. Ask her if he got any, you know what I'm saying, if she got it in her heart. Ask my nigga if she can give us something to send to you and give to me so I can be a little bit comfortable in his place of detention, essentially, Your Honor. So he's asking for money, and he's asking Miss Singleton to do that for him.
I would just say more of the same, Your Honor. As we discussed in the Singleton calls, references to support do not alone make these relevant, nor do they satisfy the balancing that has to be satisfied under 403. So I would move for those to be excluded.
And the final one?
That's July 28th, and Your Honor,
She's still not in custody.
she is still not in custody, and in fact, she's describing that she is going to the grand jury, that she's got a lawyer, Mr. Wallace asks essentially who paid for her lawyer, and I could read it verbatim, Your Honor, but I think that you can see that she's indicated that the defendant has gotten her lawyer for her.
Your Honor, there's no reference to paying anywhere in this transcript. Again, that's the Commonwealth's imagination run amok. There was a discussion of a lawyer, there was a discussion of going to the grand jury, but I don't see any kind of cohesive theme here, such as articulated by the Commonwealth. Again, we don't know the full context of this conversation because it's only a part.
They subpoenaed me to go in front of the grand jury, and I got a lawyer. That's why I got a real nice lawyer, a good lawyer from over there. Wallace. Yeah, my nigga. Singleton. Yeah. Wallace. My nigga got you with that? Singleton. You already know. Wallace. All right. Say no more. I think it's pretty obvious, Your Honor, what we're talking about, particularly since Mr. Wallace refers to Mr. Hernandez by that name on other occasions, and you know, Your Honor, from the evidence, that it's replete in the text messages of how they refer to each other. It's pretty obvious, Your Honor.
It's obvious to Mr. Bondo, Your Honor, but we obviously don't share it.
The court finds that some of these recordings are admissible. I will issue, hopefully today, a decision just setting out my rulings, and I will highlight on the proffered transcripts those portions that the court deems admissible and relevant and more probative than prejudicial. To the extent there is anything before any redactions are made to the recordings, the defendant should advise the Commonwealth to the extent it believes that if that is going to come in, what else in the recording it believes should come in to make the statements in context.
If I could just add on that point, Your Honor, I don't know if there's still confusion on this. We have never been provided with complete transcripts of these
To
conversations.
the extent they have not been transcribed, you have been provided with what other transcripts they have. They're not required to transcribe those recordings. They're required to give you transcripts of what they intend to introduce, which they've done, which they've represented they've done. To the extent they've represented that nothing else has been transcribed, that you have everything transcribed. There may be sections of the transcripts that I don't highlight that you think those portions should come in, or there may be other portions that come in. I do in which case you may have them transcribed. You may listen to these conversations of those that the court agrees are admissible, and listen to those, and to the extent there's anything that you think should come in addition, advise the Commonwealth, and if there's a disagreement on that, I'll rule on the disagreement.
We'll do that, Your Honor. I would just ask that an interval, that a reasonable interval of time.
Yes, I will give you a reasonable interval of time, since the Commonwealth only made the designation fairly late in the game in this
Even today.
proceeding.
So, I agree.
Well,
That's
by
fine,
the time of their opposition, at least, since the court had, early on, when we dealt with this motion in limine before the trial, had indicated that the Commonwealth had to designate the specifics of what it was going to put in so that the defendant could file a motion in limine that was not generic. And that was before trial. To the extent that was only done in March, causing you to file your motion in limine on March 18, and the Commonwealth's opposition on March 23, in which they further limit what they're proposing. Yes, you will have time to.
Thank you, Your Honor.
So I will try to get that out today. We haven't dealt with here, it's not clear whether the Commonwealth is actually trying to get in transcripts, the transcripts as opposed to simply the recordings.
Your Honor, on that point, to the extent they do come in, we would submit that it's the recordings, Your Honor, that are the best evidence here.
Right, I would give the instruction that they can disregard any transcript, which differs. But I guess my first question is, and again, once I've ruled as to which come in, to the extent which recordings come in, you should also advise whether there is any dispute as to the accuracy of the transcripts, because if there is, you certainly have the right to provide your own transcripts, and if there is no dispute, whether there's an agreement that those transcripts are accurate, and absent that, the transcripts need to be authenticated by testimony as to how they were prepared and the qualifications of the person who prepared them. And I would give an instruction to the jury, of course, that they can disregard any portion of the transcript which they think differs from what they hear on the tape or recording. And the next part of the authentication issue, even if transcripts are being used, presumably the recording doesn't say Mr. Hernandez or Ms. Mercado or Ms. Jenkins or whatever. So it should, the transcripts, if there are to be transcripts used, should be female voice, male voice.
Thank you, Your Honor.
And then there will need to be some method of authentication of who actually is speaking. And at least I'm certain one of those, they're only relevant if the person to whom Ms. Hernandez is addressing his comments is Ms. Singleton. And keeping in mind that a statement by someone that it is that person isn't sufficient to authenticate. So I don't. There are other ways of doing it. You may have witnesses who may listen to a recording, I guess, outside of the presence of the jury, and that recording can get marked as as for identification. It might be familiar with the voices of the persons, but there has to be some way that the voices are authenticated.
But we would agree with that, Your Honor, and I don't think a phone number, is sufficient. It does have to be an identification voice. But that process sounds fine to us.
Obviously, Your Honor, I mean, there are a number of cases on authentication, and circumstantial evidence can be used to authenticate.
Circumstantial evidence can be used.
But obviously, it's a prerequisite, and the Commonwealth is aware of that.
Right. I mean, evidence the co-identified himself as X person is not sufficient. Ones where a phone number has been held to be enough maybe ones where there's only one person that lives in that residence.
Right.
So if a phone number is being used and it's to Miss Singleton's residence, I would want to see some case law on whether the phone number is enough. But there would appear to be other ways,
Correct.
But any ruling I make
Is predicated on us being able to
Right. Any
authenticate.
ruling I make is not intended to say these are admissible even if they're not authenticated.
I understand you.
And it doesn't deal with the transcripts, the ruling I'm making, while highlighting the transcripts as a mechanism as to what the court is allowing vis-a-vis the recordings is not a ruling that the transcripts themselves at this stage come in under Portillo, absent some other standards being met, which may be the defendant may agree that those are accurate transcripts, or they may be authenticated in some other fashion. Before we turn to the video, the defendant's motion that the Commonwealth provide the transcripts, draft transcripts or summaries of jail calls. To the extent you have transcripts, they've been provided, and otherwise it sounds like it's just district attorneys' notes on what they're hearing on it, their sort of work product.
Well, I guess, that was prompted by what happened yesterday, when there was a reference by the Commonwealth to a transcript that they could print out relating to a call that had not been supplied to the defendant on August 3rd.
To the extent there are transcripts, actual transcripts and not notes by staff as to what they think they're hearing, obviously the court is going to order that those be provided if they had not.
And that's why we sent these calls to a stenographer, Your Honors, to transcribe them. We've had an assistant district attorney who has listened to calls. She has made what she believes, in some cases, like yesterday, what the parties were saying. And she has summarized some of these things. She has gone back and forth and tried to attribute particular statements to people, but she's a prosecutor, Your Honor, and those are her notes. And that is not a transcript. It is not some version of a transcript. So it's not something that is discoverable. That's work product.
Your Honor, we've made no attempt to get at work product, as the court knows, and we're content with the court's order, and we're sure the Commonwealth will comply. And if it has transcripts of further jail conversations, they will furnish them.
Your Honor, before we move on to another subject, could we possibly take a 5-minute restroom
Sure.
break? Thank you, Your Honor.
You want a 15-minute? I want to take a 15-minute recess.
Thank you.
All rise.